Welcome to the Hammer's first virtual Constitution Happy Hour. I don't know about you, but I am so ready to crack open a beer and read the Constitution with all of you tonight. Been waiting all day for that. Whoop. Constitution Happy Hour is kind of like a book club where we all read the Constitution together. In the real life version at the Hammer Museum, we have a bar and snacks, and everyone gets a free copy of the Constitution to take home. Here we won't be able to do the free copies, but hopefully you've got your own bar and snacks happening at home. We're going to have a guest speaker speak for about 20 minutes, and then we'll have a Q&A roundtable discussion with all of you in the audience for about another 20 to 25 minutes, and the whole program is going to be around 45 minutes. If you have a question for the moderator, for our guest speaker, please raise your hand digitally with the blue button, or you can type your question into the chat box. And when we get to the Q&A portion, we will be looking for physically raised hands during the Q&A. And if we call on you, we will unmute you at that point and you will be live on the air. We'll try and get to everyone's questions, but we apologize if we can't get to all of them. So the Hammer's Constitution Happy Hour is part of a larger project called My Daily Constitution, created by the LA-based artist Linda Pollack. The idea is to bring people together and engage in creative dialogues around democracy and society. Linda Pollack first began My Daily Constitution for a 2002 art exhibition called Democracy When at the Lace Gallery in response to the Patriot Act. Since then, she's initiated Constitution Cafés in bars, libraries, cafes, parks, restaurants, churches, and other places where people gather. To quote Linda, "Our Constitution, our democracy, is about interpretation. And interpretation means a collective, active dialogue, not just passive consumers and lawmaking producers. The US Constitution is a living document, part of our quotidian life, influencing us in both large and small ways daily." So part of the reason we're doing Constitution Happy Hour is to see how the Constitution affects our daily lives. And we want these programs to be relevant in real time to what's going on. So today's talk is going to focus on federal and state powers during an emergency. We've heard a lot of back and forth between the president and various state governors over the past 8 weeks about who has the power to tell us to stay home or open for business. And where precisely do our representatives get the power to force us to stay home during a pandemic? Is it constitutional? And is it federal or state power? Also, at what point does government action violate our rights as individuals and veer unconstitutionally into territory that they could be sued for? Well, luckily, we have a brilliant constitutional scholar here today to break it all down for us. Professor Jessica Levinson studies the law of the political process, including election law and governance issues. Her work focuses on ethics, political corruption, voting rights, campaign finance, ballot initiatives, redistricting, term limits, and state budgets. Levinson regularly appears as a legal and political expert on television and radio and in print. She's the co-host of the new podcast, The Legal Eagle Files, and has a weekly legal segment on the Los Angeles NPR station KCRW. She's also an op-ed contributor for NBC.com. She served as the president of the Los Angeles Ethics Commission until 2018. She's also the founding director of Loyola Law School's Public Service Institute, which is dedicated to creating the next generation of leaders in government service. In addition, she's also the associate director of Loyola's Journalist Law School. So hello, welcome, Professor Levinson.
Hello, thank you so much for having me. Constitution Happy Hour is one of my favorite things to do. We did one, it feels about 3 decades ago, but I think it was maybe right before Valentine's Day-ish. And I'm so excited to see all of you. I'm really excited to take you on this small journey through the Constitution. And so as Claudia mentioned, and I do want to thank the Hammer and Claudia so much for letting me be the first one to do a virtual happy hour. I'll kind of beg your forgiveness a little bit when it comes to the technology. And so as Claudia mentioned, we're really going to talk about 2 different things. So the first is going to be basically, what does the government get to do to you? Meaning, how much power specifically do the states have? And then that's going to be part 1 of our discussion. Part 2 is going to be, what is our recourse as individuals? So what remedy do we get for the government really intruding on our lives in ways that were kind of unfathomable even 3 months ago. So that's how we're going to set it up. Basically, what does the government get to do to you? And what do you get to do to say, no, you've gone too far? And I'm really excited to do this topic because we hear about this in the news all the time. Unfortunately, it has become a partisan battle largely, but I'm hoping that as you come along with me, you'll see that it actually really is just, these are legal questions. And I think they have pretty straightforward answers. So I'm going to ask for the slides to be called up. And as I said, part one is, where do our representatives get the power to implement these stay-at-home orders, these shelter-in-place orders, isolation orders, quarantine orders? This is a question I get a lot, which is basically, isn't this enormous government intrusion into our lives? And the answer is absolutely. There's no question that I think we all today feel the government reaching into our houses, telling us what we can and can't do. So part number one, I'm going to ask for the next slide now, is how does the government have that power? And the first answer is federalism. So the first answer comes to us from the 10th Amendment, ratified back in 1791. You have the text of the amendment up there. And for our purposes, what matters is that the amendment says if the power isn't given specifically to the federal government, then it resides in the states and the people. So our federal constitution is set up in a way that we have specific enumerated powers for the federal government. If they don't mention something, and if they, meaning the federal government, doesn't specifically prohibit an area from being under the state's purview, then it's up to the state. And so that's how we get state police power. So I think I'm actually going to ask for the slide to come down for a minute. So you don't have to look at the slide as much and we can look at each other. So question number one is, where do our representatives get the power? And the first answer is federalism, the 10th Amendment, and the 10th Amendment that gives states police power. So let's talk about police power briefly. It doesn't mean what it sounds like. It doesn't just mean the police get to do something. It's much, much broader. And actually, I think what many of us are experiencing now is that it's far broader than maybe we ever would have envisioned. And so police power means the health, safety, welfare, and in some cases, morals of our residents and citizens can be protected by the state. And this is actually something that, because of the federal constitution, the states have the power, and many states in their state constitutions specifically lay out that power and then give even more specificity to that power in state statutes that are passed by the legislature. So how ingrained in our system is police power? We have, centuries ago, one of the greatest legal thinkers, William Blackstone, wrote about how you should think of the police power like a well-governed family, where our state basically has the power to protect us, to keep us together, and to keep us safe. So the initial understanding of police power was really kind of akin to an old-fashioned household in a way, where somebody can run the place and somebody can protect all of us. And so where else, that's kind of the foundation of the police power. Where do we see it in our country? We see it from the very beginning, the founding of our country, and we see at the very beginning of the US Supreme Court cases talking about, they use words like vast and broad to describe this police power. It essentially says anything that's not reserved by the federal government, if a state thinks they need to use that power to protect you, they will. And so the kind of thing to remember about police power is, what does it envision? Well, it envisions things like, for instance, cramping down or camping down on civil unrest. It envisions things like protecting our safety. But the quintessential example of police power really is what we're living in right now. It's this moment of an epidemic or a disease. And it's the idea that we can't be kept safe by, on our own as private individuals, just deciding, well, I think these people will stay home, or this isn't safe to do, so these people probably shouldn't go to work. There has to be a concerted effort by our government. And that's why when we read in the news about police powers, it feels like this power is so vast. And the answer is that it is. So if you think about where we were in February, let's say, and if you think about the police power, you'd have police power on one side of the scale, and then you would have other constitutional rights that were on the other side of the scale, and they were about equal. Now, the second you hear the words global epidemic, the scale shifts in almost an unfathomable way, and it just is like an elephant sitting down on one side of the scale, and you have police powers come up so quickly and with such vast with such a vast reach. So part one, I sped through this a little bit. You could do hours in a law school classroom on this, but part one is, how does in California Governor Newsom get to tell us, when you walk outside, I want you to wear a mask, the schools should be closed, I might close the beaches, you can't go to work? The answer is the state police power. And again, how do we have that? Both by the federal constitution that tells us that power resides in the states, and then in the state constitution that basically reiterates that power. So now I'm going to actually ask for the slides to come back up. And we just talked about the vast reach of the state government. And now I want to talk about the fact that that is not absolute, that it still is, as we just talked about, there's another side to the balance. And so part two of what we wanted to talk about in this kind of like tight, bite-sized Constitution happy hour is, at what point does the government go too far? At what point do we say, we know the state has a lot of power when it comes to protecting us, particularly from epidemics, but it's not absolute, and you've trampled on certain constitutional rights. So first thing that I want to say is, when it comes to this question, it's a two-part test. Whenever you're asking yourself, basically, is something constitutional, is something not constitutional, you're asking yourself two questions. This is a test that was created from the Supreme Court. We use this test in all different areas of the Constitution. And the test goes like this. Prong number one, or question number one, is, does the government have an important enough purpose? Now, when it comes to, let's say, commercial regulation, the purpose has to be important, but not super important. When it comes to regulation that might affect our fundamental rights, like our right to speak, like our right to even go to work, like our right to travel, it has to be a really important state interest. So again, prong number one is, what's the state's interest? Prong number two is, and how well is the state law or restriction designed to serve that interest? So for instance, you can imagine during, let's say, just a normal flu season, the state interest would be the same as it is now. It would be to protect us. But if the state decided to implement the same kind of restrictions we have now, where we had to shelter in place because of a typical flu season, that wouldn't be the right fit. You probably satisfy prong one. It's a good reason to try and make sure people are safe from the flu. I don't know that it would be important enough, but you might get there. Prong two is where you'd really have a problem because the fit is just way off. The government reaction is completely overblown and completely overbroad when it comes to trying to keep us safe from influenza. You can't tell everyone to shelter in place for that or for the common cold. And so again, whenever we're talking about does a restriction that we implement by, again, part one, the state police power, does it hurt somebody's constitutional rights? We're always asking those two things. What's the state's interest? Is it important enough? And how does the state try and accomplish its goal? Is it overbroad, or in fact, does it not go far enough? So with that kind of 2-minute explanation of a big part of constitutional law, I want to actually next move to the issue of unconstitutional under what. So this is one of the things that you probably read about in the news, hear about on TV or the radio, which is people just say it's unconstitutional or it violates my constitutional rights. For me, if that's all I hear, that is almost a dead giveaway to the idea that they don't specifically have any idea what's being violated and that it's just another version of saying it's unfair. So it is entirely possible that government action when it comes to a pandemic could be unconstitutional, but you have to hook it to a specific constitutional provision. And so I want to walk through those constitutional provisions together. And again, the test for whether or not they're violated is the two-part test we just talked about. But you have to hook that test to a certain part of the Constitution. So I'm going to ask for the next slide to be called up. And this slide, as I just said, is basically what constitutional remedies do we have and based on what part of the Constitution. So many of you may have read about lawsuits that were just filed by business owners, by individuals, by people who want to travel state to state. And they all have a kind of a similar flavor of talking about these specific constitutional provisions. So let's take the first one first, the Equal Protection Clause. So the Equal Protection Clause sounds like it has very broad reach. In reality, it's actually not that robust, but it says the state can't deny any person within its jurisdiction equal protection under the law. What's the most kind of egregious example? It would be a state law that specifically targets women or that specifically targets minorities. It would be some sort of state law that says, you know, you get a tax credit for this unless you're a woman. Women, we don't think you should get a tax credit because we're sure you have a husband at home who's working and you don't need it. Or it's perfectly fine to stay out and go to a bar until 2 a.m. unless you're a member of this minority group. And then we think you might go a little too crazy. And so you have to go home by 1 a.m. instead. These are laws that on their face, they just smack of equal protection in the sense that you're not treating similarly situated people the same way. And equal protection doesn't actually mean everybody has to be treated equally all the time. It just means you have to treat similarly situated people equally. So what does it mean here? The argument is that we've drawn two different classes of people when it comes to these shelter-in-place laws. And so class number one by which I mean group number one, is a group that are being told you are essential workers, you have an essential business, and you get to go to work, or in some cases, even you have to go to work. Group number two is the non-essential workers or the non-essential businesses, and they're being told you can't go to work. And so some recent lawsuits, and I mean really recent, like a day or two ago, have said, you government don't get to line draw between those two people. You actually violate the equal protection of the people who you've characterized as non-essential workers. Now, what's the punchline to this one? I think very unlikely to be successful, because the Equal Protection Clause really cares about people who are members of a protected class, who have historically been discriminated against: women, minorities, language minorities, religious minorities. The Equal Protection Clause doesn't come in with its full force as much if we're talking about commercial regulations like we would be here. And again, remember the balance. It's state police power to keep us safe versus equal protection clause. And again, what's the punchline? Neither is absolute. It's going to be a balancing act. So this is a time where if we were all together in the studio, you would start yelling at me / very politely asking questions. As Claudia said, we're going to do the questions at the end. I'm not going to go for too long just talking, because I really, really want to hear from you as well. Right now, we're going to move on to the second constitutional provision that might be violated here by these shelter-in-place or quarantine or isolation laws. And that's the Due Process Clause, also in the 14th Amendment. And this is typically a very popular clause in kind of common vernacular, which is like, government, you can't take away my life, liberty, and property. And the truth is, the government actually can. It just doesn't have an absolute right to do so. And in this case, the lawsuits typically will focus on one word, and that's the liberty word. And they'll say, you government don't get to tell me that, let's say it's a curfew law, I can't leave the house after a certain time, or I don't get to go to work, or let's say you're a restaurant owner, I can't open up my restaurant and have in-person service. And this is actually a pretty quick one, because the case law is quite clear that your liberty interest will be subsumed, again, by the state's police power. That when it comes to this liberty interest and due process of the law, one, the state can actually reduce your liberty quite a lot. And two, by implementing these executive orders, very likely the state has actually given people the process, the due process that they are entitled to. So with that, we'll move on to another word. We're going to focus on property, but actually talk about it with respect to the Fifth Amendment. And so the Fifth Amendment talks about the takings clause. And this says that the government doesn't get to take your private property for a public use unless they pay you for it. And this one makes a lot of sense to most people. I mean, you just on an intuitive level, you can't really imagine that, officials from the government would knock on your door and say, we like this house. We think we're going to use it for a park. It's in a beautiful place. We're not going to pay you anything for it, but we need you to move out within a week. I mean, that would be kind of the most blunt force example of what a taking would be. Government comes to your door. They say, we like your property. They say, we're going to use it for a public purpose, let's say a park, but we're not going to pay you for it. And the best kind of example of how this clause actually is not, again, not very robust is in a really old case dealing with apple orchards. And in that case, the government actually cut down somebody's apple orchard because the trees were infested and they were spreading disease to a lot of different properties. And the court said, no, you had a really good reason for having to cut down that private property. We don't think that the compensation clause kicks in. So that's not actually a taking. Now, all of you are kind of thinking to yourself right now, well, if you can prevent a disease on apple trees, then it seems quite likely that you can prevent a disease that will hit humans and that it would not be considered a taking. I think that analysis is exactly right. So, other examples of how the takings clause isn't really all that robust. There was a case a while ago where police kind of damaged somebody's property because they were the next door neighbor of at that point, alleged criminal who they were trying to essentially smoke out. And even in that case, the court said there isn't a taking here. A taking really is you either completely take over somebody's property by destroying it, or you say, hey, we're going to live in your house now. Go find some other place to live. And none of those scenarios are present here. What we have is a temporary situation. And what we have is a situation, again, where we have that really important countervailing interest. Okay. With that, we're going to move on to the next idea, which is the right to travel, which is actually found in two different privileges and immunities clauses. I'm not going to read these to you verbatim. I think instead what I'm going to do is talk to you about them. Basically, there's a privileges and immunities clause in the original Constitution, Article 4, and then there's also a privilege and immunities clause in the 14th Amendment. And for our purposes, there's two reasons we care about the privileges and immunities clause. The first is the idea that we are one nation. And yes, we have 50 states, but we're one nation, and you should be treated, at least as a citizen, the same way when you move from state to state. Meaning, if you're a resident of California, if you want to travel to Arizona, they don't get to treat you worse just because you're from California. They don't get to, if you decide to travel in Arizona, say, typically everybody else gets to take this road, but I see you have a California license plate and we'd really rather that you not take any highways, just take surface streets. And the Supreme Court case law on this is really interesting. It brings up this idea, there's language about basically being a good neighbor. And what the founders of the Constitution were trying to do is make sure that we were a closely knit country, that we weren't just something more akin to the European Union, where we have a bunch of different countries and then we're kind of loosely knit together. So why does that matter? Why do those privileges and immunities matter for our purposes of a quarantine or shelter at home order? And the answer is that some of these quarantines actually have different rules for out-of-state residents. So some of these shelter in place or quarantine laws say, if you're coming from another state, you have to quarantine for 14 days basically before we let you loose in our state. Some of the states say, if you come from any other state, some of the states say only if you come from a quote unquote hotspot. And so there is a question as to whether or not you are treating out-of-state residents differently than you would treat your own residents when you do that. I think there's a good answer to that, but that's the constitutional question. There's a second constitutional question when it comes to the same clause, the privileges and immunities clause. And the second question is about the right to travel. And essentially what we're talking about is both the right to travel within the state and the right to travel out of the state. And what a very recent lawsuit has said is, well, these shelter in place laws violate my right to travel, meaning really my right to go to work, or my right to go to a large gathering, or my right to visit family. What another suit, I think this was in Michigan, recently said is these shelter in place laws, they prevent my ability to go to a neighboring state and then come back. I think the answer to all of these is what I've been saying before, which is, in a normal circumstance, could the state tell somebody who comes from out of state, you don't get to be here until you quarantine for 14 days? Absolutely not. In a normal circumstance, could the state tell us we don't get to travel to our work? Absolutely not. In a normal circumstance, could the state really infringe on our ability to travel, again, both in the state and from in the state to out of state and back? Absolutely not. But these are not absolute rights. These are rights, again, same thing, balanced against the police powers. So now I'm going to ask for the last slide. I can't actually see your sighs of relief if there are any, but this is the last constitutional provision that I want to talk about. And it's actually not a constitutional provision. And this is the one, I wanted to end with this because when we're talking about these shelter in place or quarantine or isolation laws, people have brought up the idea of the Dormant Commerce Clause. Now, the Dormant Commerce Clause is not in the text of the Constitution. It's something that's implied. It's a negative right. And so it refers to, I'm going to read a little bit from the slide. Basically, states can't pass legislation that discriminates against or excessively burden, good luck to anybody who knows exactly what excessively burden is, excessively burdens interstate commerce. Now, how would this come up? And again, why is that the case? Because interstate commerce and international commerce is the purview of Congress, not the states. So the Dormant Commerce Clause is really a way of telling the states, stay in your lane, don't tread on my territory. You can have laws that affect commerce, but if it goes too far, then you violate this thing that's not actually in the text of the Constitution. It's just implied in the Constitution. And so the idea is that this might be violated by the shelter in place laws for a couple of reasons. One, shutting down businesses. Obviously, certain businesses will have a large impact on interstate commerce. The other is that the laws that talk about out-of-state residents having to quarantine to come in, or the laws that really limit people's ability to go out of state, could disproportionately impact interstate commerce. That's why when states first started implementing these quarantine laws and they affected out-of-state residents, you saw them specifically give carve-outs to people who were engaged in business or essential business. And so, what's the consequence? I mean, these shelter in place, quarantine, isolation laws absolutely have an enormous impact on our interstate commerce, our international commerce, but does it rise to the level of excessive burden? I think the answer is it's a burden, but not an excessive one, for the same reason that we talked about. This is a valid exercise of the police power. So I'm going to ask for the slides to come down for a second, or actually, I think for the duration, I think we're probably done with the slides. And so, where does this leave us? This leaves us in a place where, at least for now, when we are still facing, we're not even sure if it's the end of the first wave of a global pandemic. We have this incredibly robust police power, which is not absolute, but which is very powerful in comparison to all of the constitutional rights that we just talked about. And at this point, I think that any of these suits, again, based on equal protection, based on the takings clause, based on the due process clause, based on this issue of the right to travel, based on Dormant Commerce clause. I don't think they're successful right now. Now, two things could shift. One is as time goes on, the emergency seems less powerful. And, the other thing is a government could implement a law that's just way overbroad. And that is something that we need to look for. So with that, I am now seeing the time again and realize that I blew the timing a little bit. So our well-rehearsed moment right now is that I say to Claudia, I would love to get questions from the audience. And as long as people can stay, we'll love to answer them, and we'll promise to be quick about it.
Hi, everybody. That was completely fascinating. I learned so much. I did not know any of those things, to be honest. It's so interesting to read the Constitution with you, Jessica. So for those of you in the audience, I just want to say you might want to change your Zoom settings now to gallery view. It's in the upper right corner. That way you'd be able to see all your fellow audience members. And when we do this in a live environment, we try to make it as interactive as possible. So we're totally experimenting with Zoom and how interactive you can get with Zoom. It's not that easy, so bear with us, but we have three options for you if you want to ask a question of Professor Levinson. You can ask a question verbally, either by raising your hand digitally using the blue button. We will also be looking out for physically raised hands. So if your video is on and you raise your hand, someone will be looking for you and they'll let me know. And then if we call on you, we will unmute your audio and you can go ahead and ask your question live. Or alternatively, you can type your questions into the chat box below and I will read them aloud to Professor Levinson. We're going to try to get to everyone's questions, but we apologize if we can't get to everyone. And just to remind you all, this is being recorded, so if you don't want to be recorded, please turn off your video, and you can still type your questions into the chat box at the bottom of the screen. So, so Jessica, here, and we can lose that slide. Here's our first question from Josu Whistler. Trump issued an executive order to have the meatpacking plants reopen or stay open, and some workers don't want to work because of the risk. In response, two governors said they'll not allow such workers to collect unemployment insurance. Is this constitutional? Are the governor's actions constitutional?
Yeah, that's a great question. What we didn't talk about, because I was worried I was going to go over time, which of course I actually did, is that the state has police power, but the federal government actually has some police power as well. And you typically see that through two things. And the question talks about the second one. One is the CDC using its power to protect people, and the other is through executive order. So if by executive order, the president says you have to go to work in its specific industries, if those people are working, it's not really a constitutional issue. It's more of a state law issue as to whether or not they would be eligible for unemployment. I'm going to punt on it a little bit in the sense that I'm not totally familiar with that state law and what it says, but my suspicion is that and again, it's a suspicion, is that might be permissible. And we didn't talk about this with respect to federalism, but the federal Constitution specifically gives, as we said, state police power to the states. But where there is a federal directive and a state directive that directly conflict, then we have a different idea called the supremacy clause, and then the federal government trumps.
Interesting use of the word trumps.
I knew you were going to say that, yes.
So, okay, I'm going to go to the next question. We have a person named Perry next. Perry's going to ask their question verbally. Perry, are you there?
Yes, I'm there. And my question is a very simple one. It said, if you want, you can indicate a question by pressing the blue button. And I have no idea what blue button you are referring to.
Someone's going to answer that in the chat because I can't see the blue button either since I'm in a different mode. So I will let them respond.
Fair enough.
Next on Lex Roman. Lex Roman has their hand up.
Hi. My question is about the seizure of private property. So given the state's police power, what I'm noticing with Gavin Newsom is that for the hotel project, for taking over hotels for the homeless, a lot of that power is going on to the county. So I'm curious how the state police power sort of cascades down to the counties and the.
Yeah, that's such a good question. And it was kind of almost brought up today where we thought that Governor Newsom was going to shut down not just not just certain beaches, but all beaches. And so tell me, when I'm done with this, unmute and tell me if this answers your question. The answer is typically that the state sets a floor. So, but counties and cities can do more. They can be more proactive in terms of protection, but not less proactive. So if you think about, let's say we had a statewide mandate that if you're outside of your house, you have to be 6 feet apart from somebody. This isn't actually the state mandate, but just hypothetically, let's say it is. Then the county can't say, no, we're okay with 4 feet. The county can say, actually, we think here 12 feet is better. So the county can be more aggressive. The city, and this is typically, please don't, file a lawsuit based on what I'm saying here, but typically city of the county can be more protective, more aggressive, but not less so. So what we've seen right now is actually a pretty consistent approach from the state government and the counties. But what we saw last night when apparently the Newsom administration was calling counties and saying we might shut down all the beaches is their understanding that the state could jump in and basically say, no, we're forcing you to do this. And so again, the county can't pull back and say, state, you've gone too far, but the county could go further.
Yes, that answers my question.
Okay.
Great. Our next question is from Mark in the blue t-shirt.
All right, thanks. So early on, we heard a lot of talk about emergency declarations being made. And I'm curious as to when an emergency declaration is made at the state level or the county level, does that sort of trigger the ability for the state or the county to enact more restrictive things like we're seeing today? Is that sort of a trigger event or a trigger words or whatever you want to call them?
And by what we're seeing today, you mean like a shelter in place or closure of the beach? Yes. So trigger word is such a loaded term, but yes, typically what you'll see is there'll be this kind of threshold, exactly what you said, where there'll be a threshold emergency declaration by the state and or simultaneously by the county and by the city. And what that emergency declaration generally does is it allows different powers to kick in. It's kind of along the same lines as when President Trump, it feels like about 5 years ago, but I think it was like 4 months ago, declared a national emergency and said, we want to build a wall. That moment where you say national emergency or state emergency gives you new enhanced powers. And for instance, on the county level, you can say tactical alert, and then you get more law enforcement out immediately. So hopefully I understand your question correctly. And the answer is that's absolutely right.
Yep, perfect, thank you.
Next, we have a question from Hope. Hope, you're live.
Oh my gosh, thank you so much. There was a question in the chat that I just wanted to check in about, which was about what you mean when you say robust, which I'm just a legal assistant, so I had a sense of what that meant, but can you just answer what like lawyers and attorneys mean when they say robust?
I can answer what I mean when I say robust. I mean super powerful, highly charged. So what I mean is if what was happening right now is there's a really bad cold going on, state power is not at all robust to try and protect us. Global pandemic shoots up, state police power super robust. It's uber, it's kind of whatever synonym you want to use. Yeah.
Great. Now we have a question from Ellen Brooks.
Hi. I have a question. I'm not sure historically it's ever happened, but one of our great liberal spokespersons, Bill Maher, thinks that if Trump decides, even after losing the election, that he's not going to give up, what recourse is there to enforce a constitutional misgiving or mistake for somebody who does something that is really inappropriate?
Yes, I love that question. And thank you, Dr. Brooks, a very good family friend. We're very happy to see you. Very happy to see a familiar face. So the question, sorry, the audio cut out for a second, but I think the question is basically Trump loses and he holds over. And what happens? So I'm going to kind of back up from your question a little bit, which is there's been questions that are not just if he loses, but before that, what if he tries to change the date of the election? And the answer is date of the election is set by Congress. It's set by federal statute. You can only push it back until, I believe it's January 20th, and then the term ends. It's very clear that then your term ends. So, in answer to your question about what if he just says it's January 21st, it's February 1st, I like the Oval Office, I'm great at this, I'm here. There's a couple of different things that would kick in. There would be a suit in the Supreme Court, and the Supreme Court would at that point say, this is unconstitutional, you need to leave. Now, the Supreme Court doesn't have a military or an army behind it. So we would have to assume that we would act on this behalf. Now, if President Trump just says, I don't care what the Supreme Court says, at that point, we're in basically two worlds of hurt when it comes to a constitutional crisis. We have a president who won't leave and a president who won't adhere to the Supreme Court precedent, who won't adhere to a Supreme Court rule. You would see enormous political pressure, I think, by Congress, by members of the administration. If that doesn't work, and I really want to say absolutely last resort, then you do start talking about military affecting a not peaceful transition of power. And I think I'm going to actually, Claudia, correct me if I'm wrong, but I think we're going to be doing another discussion of totally focused on the election. So you keyed me up to that brilliantly, as if we had all texted this morning about it.
Which reminds me, I just want to put in a plug here that it's probably a good idea for everybody to register to vote by mail. And I think it would really help the Secretary of State if we did that now and not 2 weeks before the election. So in this whole idea of leveling the curve, we should do that by registering now to vote by mail. Anyway, okay, so we have a live question now from Scott Wymer, also about presidential powers. Scott, you're on.
Hi, let me first say that I really appreciate the clarity of your answers, both on TV and here right now. I have two questions. One is, how is it determined what's in the president's purview versus the governor's purview versus a more local person's purview? And the second question is, could you please comment on civil liberties in this country versus some other countries we've been hearing about lately, like Israel, or Korea, or China?
Yes and no. So I really appreciate that. I think my parents are on, and I'm going to assume that they fed you that those initial kind words. So the second question, I kind of hate it when people pretend that they're an expert on more than they are. And so in terms of the second question about international comparison and how we are in terms of civil liberties, I would say that I just saw this, I think this morning or last night, where in terms of freedom of the press, we're plummeting. Kind of more than that, I'm going to punt. And if you maybe well, I don't know if you want to write your email in the chat, but if you want to somehow contact the Hammer, I'll put you in touch with somebody who can answer that better. The first part of your question, I think I can kind of answer, which is it's kind of a vertical question of who gets the power. Is it the president? Is it the governor? Is it the county or city? And so the answer is the president has the power that's enumerated in the Constitution. And so I wish I could just kind of say that and say, well, I'm all done here. But you probably know the Constitution is really this maddening document that does not give a lot of specificity or clarity. We know that the president has enormously broad authority when it comes to national security, when it comes to immigration, but we don't know exactly where presidential authority ends in some circumstances. And frankly, the Trump administration is like this stress test on executive authority, where we had the blueprints and now the Trump administration is kind of pushing on the walls, and some of them are falling away, and we're seeing the Constitution isn't really protecting us the way we had envisioned. The answer for the governor is a little bit more straightforward, which is typically it's in every state has its own constitution, and those powers are enumerated in the state constitution and then clarified in the state statute. And then when you go down even further, the question for county versus city, first it's a question of whether or not you're a general law city or a charter city or county. But the idea is kind of akin to what I said before, which is the county supervisors or the mayor have basically the power that's left to them. They can decide to go further in protecting us, but it's clear that the state has authority to set a floor.
So we're going to go a little over time. I said 45 minutes, but I hope you're all interested enough to stay with us. And if not, have a wonderful evening, but we're going to keep answering some audience questions. I am very, very honored for our next questioner, Professor Albert Carnazel, who was the chancellor of UCLA for many years and had very steady guidance for our university. And it's just thrilling to have him here. Hello, Chancellor Carnazel. What's your question?
Hi, Claudia. Yes, well, it's two parts. First, to let people know if they want to raise their hand, they can click on participants and you'll see it'll come up on the lower left. You'll see the blue hand.
Thank you.
I'll just use that. So that's for others. Another is to say, I think, and I appreciate your reaction to it, I think the situation you described with President Trump not wanting to leave office is worse than the worst case, or not as bad as the worst case. And that is because Congress ceases to exist on January 3rd. And so the House, there's no longer a House of Representatives on January 3rd, and there's only 2/3 of the Senate as of January 3rd, because they're out before the January 20th when the president is out. So it's hard to see what the government does, because in essence, the only thing you have for a Congress is 2/3 of the Senate. And I don't know how the Constitution would deal with the Senate or all the stuff that's in there about the powers of the Congress if there's no House of Representatives. Do you have any thoughts on that?
One, I appreciate the very kind clarification correction. Do I have any thoughts on that? My initial reaction is that the power that the House has or the power that the Senate has is really just political pressure at that point anyway. So it's not like they would take a vote to say, oh, you have to adhere to the election, because we know that, they're not the ones who run the elections at all. So I definitely would want to think this through in a little bit more detail, but my response is, as long as there is some plaintiff withstanding, meaning they have an injury in fact, it's caused by the specific issue and it can be redressed by a win, then you can still have somebody go to the Supreme Court, and then you can still try and effectuate that decision. And then if the decision isn't adhered to, regardless of how many members of Congress you are, you still have now, as I said, 2 constitutional crises. And at that point, it's not clear exactly how we would call in the military, though. That's the issue.
Thank you.
I love that background.
I know, the Mars rover. Oh,
See what you did, Philip Brooks? You spawned a whole line of questioning.
Right.
so our next question is from Carol Magnuson. Carol, you're live.
Oh, over to Charles.
Hi, Charles.
Thank you very much for this program. It's just such a opening of a lot of thought, and the preparation for it displays a lot of understanding of what a lot of people think about. My question has to do with due process. I mean, with the weight of evidence, and does it change depending upon who the defendant is, or what the issue is? That is it the weight of evidence? Is it overabundance, clear and equivalent, or reasonable beyond a doubt, or something of that sort?
Okay, so Claudia, you'll correct me if I didn't hear the question correctly, but I think the question is basically, you go into a court of law and you say, hey, I'm a business owner and I have a right to travel to my business, or hey, I'm a business owner and you unconstitutionally infringed on my rights because you said I was non-essential. And so kind of how much evidence do you need? Do you need to show beyond a reasonable doubt? No, that's for criminal cases. Do you need to show clear and convincing? Maybe. So clear and convincing is like, let me just say I'm not an evidence professor, but clear and convincing is like much more than just more likely than not. Or do you need to show preponderance of the evidence, which is like 50.1%? And the answer is that it's an overlap of evidence law and constitutional law, which we talked about. I think that right now, what a judge would say is probably preponderance of the evidence. And that's in part, and I'm going to emphasize probably there because I'm not an evidence expert. But then I'm also going to say, I don't think at this moment, anybody wants to be the judge saying, government, you went too far in trying to protect people. Now, again, maybe that's different when we're talking about Memorial Day, but judges are people too. And I think they're going to kind of give states the benefit of the doubt for a bit.
Well, I guess what my other point is that if the government does the government, if it's challenged, really in a position to say we acted reasonable, and you have to show that that reasonableness is inaccurate?
So if you, well, I guess it's kind of a question of whose burden is it? So if you are the plaintiff, if you're the business owner, then it's your burden to show that the government violated some, constitutional provision, some right to travel, some equal protection, some due process, some, we didn't talk about it, but right to assembly. And so it's the plaintiff's burden. The question is kind of how high is the burden? And how much evidence does the government have to come back with? And the kind of fuzzy answer I'm going to give you right now is I definitely know it's the plaintiff's burden. And I definitely think that a judge will give the government the benefit of the doubt, and that they wouldn't have to prove, again, beyond a reasonable doubt, or probably even clear and convincing. At this point, we're talking about more of a rational showing.
Thank you.
Great. Now we have a question from Jim Steinberg about Second Amendment issues. Jim, you are live. Maybe I should read Jim's question.
Yeah, please do.
Okay, Jim asks, if a new administration in Congress outlaw all AR-style rifles, would the government need to compensate owners? And to what value? Would it be $200 a rifle, $1,500 a rifle? How does that work?
Okay, so I'm gonna really be a lawyer on this one and give kind of a big caveat, which is I'm not a Second Amendment expert. The Hammer has a great Second Amendment expert, but it's kind of a question of it's like a Second Amendment and Fifth Amendment crossover in the sense that it's confiscating guns, but then it's also your property. And I think that the answer is you would need some sort of just compensation. How you would set that would be based on experts of fair market value. Claudia, did I hear the question and or partially answer the question?
Yes.
Okay.
So they do need to compensate owners, just the value is up in the air.
So yes, the idea that, and again, email Adam Winkler to correct me, but the idea that the government can just come and say, you have a gun in your house, I'm going to take that. That's why the government typically has buybacks. And you see this happen not infrequently.
Thank you. Okay, so now our next question is.
Let me just say one other thing on that. It's important to keep in mind the difference between possession of a gun and use of a gun. And that could also affect the analysis. And that's kind of the outer bounds of what I know on that.
Okay, our next question comes from my wonderful colleague, Gwen DeGlees Moore. Gwen, you're live.
Hi, this is Gwen's husband, Jordan DeGlees Moore.
Oh, hi, Jordan.
I just had a question. Does the professor have any insider comments about what happened at the Michigan State Capitol today with the heavily armed showing? Someone called it a protest. Maybe it was more than that. I thought it was kind of disturbing.
The news I heard from Michigan was a state upholding the governor's shelter at home ruling against an argument that it violated due process. So I guess to take your question kind of a little bit more broadly in terms of the protests, we didn't talk about another constitutional right, but there is the constitutional right of freedom of assembly. But again, that can be limited too. So with respect to these protests, you basically have to implement laws that are neutral, meaning you can limit protests, but you can't just limit people who have a certain viewpoint. So it has to be that all protests of this size or at this time or at this place are deemed problematic. So you can't just say, we don't want anyone who's against the quarantine, but it's okay to have people who are in favor of the quarantine. So my response is, it's really the issue that we've been talking about today, which is, it's states' ability to say you have to shelter in place, and then you weigh that against the right to assemble and freedom of speech. And the government can actually tell you in a lot of different circumstances, you don't get to speak either in this way or at this time or in this place. I mean, we don't get to have parades in the middle of the city at 8 a.m. when people used to work, because we decided that would be too much of a hazard. But again, it has to be any parade, not just parades that are pro-life or pro-choice, et cetera. So you have to be really careful that the government isn't picking perspectives, that they're just picking health and safety, not who they like and who they don't like.
Thank you.
I have another question here. Hang on, okay, there we go. This is coming from James Robinson. James asks, is it appropriate for the Attorney General, Bill Barr, to speculate as to what actions a governor insists upon may or may not be legal or constitutional for a governor to insist upon, in effect encouraging lawsuits? Does that make sense?
Sure. So Attorney General Barr can kind of pontificate all he wants about lawsuits and how successful they might be. And he's entitled to, as the head of the Department of Justice, join some of these lawsuits. This is, I'm only speaking for myself here. I'm not speaking for Loyola or the Hammer, but my sense is that the idea that the Attorney General would join in some of these private lawsuits against these shelter-in-place laws is a political decision. I think that Attorney General Barr knows that these are not likely to be successful lawsuits. And again, I started with this, but this isn't a political calculation. So it's not a question of, does this Democratic governor have the power, or does this Republican mayor have the power? It's just, does anybody who sits in that office have the power? Which is kind of a long way of saying Attorney General Barr can kind of pontificate and try and muddy the waters and try and throw some meat at his supporters, and he can join lawsuits if he wants to. He needs to make sure that it's not frivolous to join. But I don't think that he believes that these would actually be successful.
Okay, thank you. Here is another question coming from Deborah Donson. She is referring to the US Constitution due process clause in the 14th Amendment. She asks, does the concept of situated apply to essential and non-essential worker situation?
Sorry.
If the 14th Amendment says the state can't deprive any person of life, liberty, or property without due process of the law, does that concept apply to essential and non-essential workers? I think we might have covered that, but.
So maybe that's kind of the reverse. Instead of preventing people from doing something, forcing people to do something.
Yeah, what you mean.
And yeah, we kind of talked about one aspect, which is limiting people's activities, but we didn't talk about that much about the other aspect, which is forcing people to do things. And I guess what I would say really broadly is I don't see that as falling within the current court's 14th Amendment due process cases for a variety of reasons. As I said, due process sounds super broad. It's like, I have a right to liberty, I have a right to property, but it's actually much more confined. And the question is answered a little bit more in terms of state laws that will basically allow the governor to tell people, we need you, you have to go to work, or the president, there's a federal statute which would allow, it's called the Something Defense Act, I'm blanking on, which essentially allows the president to force people to go to work. Like, think about war times where, you have to go make those warheads, you have to manufacture X, Y, and Z.
Okay, and we have what might be our last question. This is from Hollis Leach. Hollis asks, is there state recourse for the Northern California county, I forget which county that is, that has stated that they're going to open schools and businesses, et cetera, tomorrow, despite the stay-at-home order? And what do you think is going to happen in that situation?
Yeah, I mean, so yes, the short answer is yes, it could be state recourse. The state could say, we have this baseline, you're violating this baseline, you're violating this baseline in a way that is, that's threatening people's health. I mean, so what's important to remember, you have a liberty interest, but you don't have a liberty interest. It's not strong enough to make other people sick. And so the state absolutely could, go in and try and effectuate that order. Now, what are the ways that states can penalize people for failing to comply? One is money, and two is imprisonment.
Hardcore. Okay. Well, that's all the questions we have. And thank you all for sticking around. Now it's been an hour and 10 minutes, but it was a really fascinating hour and 10 minutes. And I have learned so much. Thank you, Professor Jessica Levinson. You're just amazing. It's so great to get all of your incredible insight. Any last messages to our audience?
I had so much fun. What great questions. I mean, it's a really hard time, but I love the discussion. Thank you so much. And thank you, Claudia.
Thank you. Good night, everyone.